Well, friends, we just learned that the Georgia State Court of Appeals will take up the issue of whether Judge Scott McAfee was correct in his ruling that District Attorney Fani Willis is not disqualified from prosecuting Donald Trump. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, today we learned that the Georgia Appeals Court will take up Judge Scott McAfee's ruling that District Attorney Fani Willis is not disqualified, not conflicted, need not be removed from the RICO prosecution of Donald Trump and his 18 criminal associates, his co-conspirators, his co-defendants. Now, this development, the Georgia State Court of Appeals deciding to accept this issue for review, was 1, not unexpected, 2, not a particularly good development, but 3, not necessarily a bad development. Let's talk about why that is. But as always, let's start with the new reporting. This from NBC News. Headline: Georgia Appeals Court grants Trump's request to consider DA Fani Willis's disqualification from his criminal case. And that article begins, Georgia's State Court of Appeals said Wednesday that it will consider an appeal from former President Donald Trump challenging the decision not to disqualify Fani Willis as the district attorney overseeing the 2020 election interference charges against him. The order said that Trump can file a notice of appeal within the next 10 days. A lawyer for Trump, Steve Sadow, said in a statement that the former president looks forward to arguing before the appeals court that the case should be dismissed and Willis disqualified for her misconduct and unjustified, blah, blah, blah. I don't really enjoy repeating the propaganda portion of that statement. The article continues. The DA's office declined to comment. The judge presiding over the case, Scott McAfee, ruled in mid-March that Willis shouldn't be disqualified from prosecuting Trump and his co-defendants, despite their allegation that she had a conflict of interest in the case. They accused Willis of misconduct, alleging she financially benefited from her relationship with Special Prosecutor Nathan Wade, which led to days of testimony in court about their romance. McAfee ultimately decided the appearance of impropriety created by their personal relationship should result in either Willis or Wade leaving the case. Hours later, Willis's office confirmed Wade had resigned, and she had accepted his resignation. Days later, McAfee granted a certificate of immediate review, giving Trump and 8 of his co-defendants permission to appeal his decision to keep Willis on the case. This gave the Court of Appeals 45 days to decide whether to hear an appeal on the matter. Lawyers for Trump and the other defendants then asked the appeals court to allow them to challenge the ruling. The appeals court decision Wednesday comes as Trump continues to sit for trial in the criminal case he faces in New York. It's the only one of the 4 criminal cases against him that has made it to trial. Thus far, a trial date had not yet been set for the election interference case in Georgia. Okay, friends, let's talk about why this legal development, 1, is not unexpected, 2, is not good, but 3, is not necessarily all that bad. Not unexpected. Once Donald Trump lost the battle, he lost his motion to remove District Attorney Fani Willis. Once Judge McAfee ruled, no, she's not disqualified, she's not conflicted, she need not be removed from supervising the RICO prosecution she brought, we knew an appeal was probably inevitable. Interestingly, there was no automatic or absolute right to appeal this decision. Donald Trump and his co-defendants had to file a motion with Judge McAfee asking permission, asking leave to appeal this ruling. And Judge McAfee, no doubt confident in his ruling, granted that motion. And so Donald Trump filed an appeal. And now the Court of Appeals has accepted the issue for review. So all of that was, one, inevitable. Two, not good. Why do I say it's not good? Because the people won in the trial court. The people of Georgia won. And by extension, the people of the United States, all of the voters that Donald Trump and his criminal associates defrauded in Georgia and elsewhere, but in this case, in Georgia, the people won. So of course it's not good when a ruling that actually forwards the justice ball, vindicates the rights of the voters of Georgia, when a ruling goes the people's way in the trial court, well, you'd rather not see it appealed, right? But it has been appealed, and the Georgia Court of Appeals has accepted it for review, so that's not good. You know, they, I believe, ultimately will affirm Judge McAfee's decision that Fani Willis is not disqualified, but still, it's not good. But why do I say it's not necessarily bad? That might be the counterintuitive piece, right? Here's why I say it's not necessarily bad. When Judge McAfee granted Donald Trump's motion to file this discretionary appeal, here is what Judge McAfee said. The court intends to continue addressing the many other unrelated pending pretrial motions, regardless of whether the petition is granted within 45 days of filing, and even if any subsequent appeal is expedited by the appellate court. So ordered this 20th day of March, 2024, Judge Scott McAfee, Superior Court of Fulton County, Atlanta Judicial Circuit. So, what did Judge McAfee say to Donald Trump and his criminal associates, his co-defendants, when he granted their request to file this discretionary appeal? You got it, but guess what? We're not going to stay these proceedings. We're not going to stop. We're not going to pause. We are going to keep plowing forward. We are going to keep litigating motions, resolving issues, and we're going to continue to head toward trial, period. So as you can see, friends, that is different than what's going on in federal court in Washington, D.C., here in my backyard, where the Supreme Court grabbed hold of an issue in the case involving Donald Trump's prosecution for trying to overturn the results of the 2020 presidential election. That's the case Tanya Chutkan is presiding over. The Supreme Court grabbed hold of it and they told Judge Chutkan, stop. You will not move forward, not 1 inch. You will not litigate a motion. You will not resolve issues. You will not pass go. You will not collect $200 or provide any justice to the people of the United States of America. Yes, all of that is my editorial addition. The Supreme Court didn't really say those last couple of things, but that's what they did. They brought the prospect of justice to a screeching halt in Donald Trump's federal prosecution in D.C. while they sit on that issue and take their time. But not Scott McAfee, not Judge McAfee. He said, appeal away, Donald. Again, he didn't put it in precisely those terms, but we ain't stopping. We're going to keep litigating issues, resolving motions. We're going to keep heading toward trial. So the first thing I looked for today, friends, was what did the Georgia Court of Appeals say about that, if anything, when they accepted the case for review? Well, let me read in its entirety. It's very short. Today's order from the Georgia Court of Appeals. Upon consideration of the application for interlocutory appeal, interlocutory is a fancy word for an appeal while the case is ongoing in the trial court. An appeal before the case is over, before there's been a verdict and a sentencing. It's an appeal midstream. We hear that word interlocutory a lot. Upon consideration of the application for interlocutory appeal, it is ordered that it be hereby granted. The appellant, Donald Trump, may file a notice of appeal within 10 days of the date of this order. The clerk of the Superior Court is directed to include a copy of this order in the record transmitted to the Court of Appeals. Period. What did the Court of Appeals not say? Oh, and by the way, the trial is stayed pending appeal. The case that is before Judge McAfee in the trial court is stayed, is paused. It must stop pending this appeal. So as far as Judge McAfee is concerned, they continue to plow forward. It doesn't mean the Georgia Court of Appeals can't in the future put a stay in place, but they didn't today. So the other thing that I want to take on, and we'll finish with this, is there is still no trial date set down in Georgia for any of the RICO defendants. That is a little surprising to this old prosecutor. Months ago, District Attorney Willis asked for an August 2nd trial date. Now, we don't know if she was proposing that that would be for all 15 remaining defendants, 15 of the 19, 4 pleaded guilty and are cooperating against Donald Trump and others, or if she intended that to be just phase one. I will say, having handled large RICO cases, we sometimes batch defendants together and do a series of RICO trials because 15, frankly, maybe too much to try at one time. In D.C. in federal court, we do 6 at a time. That is the maximum number of defendants that the U.S. Marshals told us they can provide security for, 6 at a time. But we still don't have a trial date set down in Georgia. It's a little surprising, especially because D.A. Willis asked for a trial date of August 2nd many months ago. Now, yes, everything got derailed with this disqualification litigation that has now been accepted for review in the appeals court. But, let's keep an eye out, maybe for a trial date being set in the coming days or weeks, because we are still just kind of treading justice water here. Yes, Donald Trump is in a criminal trial, the first ever of a criminal former president of the United States. He's in his first criminal trial, first of 4, up in New York presently, and the other 3 cases are jockeying for position, lots of moving pieces, and we are all waiting to see how the trial dates will line up, because Donald Trump will be prosecuted in all 4 cases. He will be, in part because he's not going to be elected in November and he won't be able to kill the cases against him. He will be prosecuted, hopefully, in at least one of his other criminal cases before the November election, because the people have a right to know who they're voting for, right? A convicted felon or a completely exonerated innocent man, someone who has been cleared by the jury, somebody who they were not persuaded beyond a reasonable doubt committed any crimes. The people have a right to know who they're going to cast their ballot for in November. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.